Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. This is the final lecture for the topic of business organizations. This one covers corporate dissolution and lecture, and I have lecture notes that you can follow along with. I will be doing another one that's a little off the one other lecture, so stay tuned. I said this would be the last, but it appears the exam does do a little bit of a dive into nonprofits, and I think I'd better do something about that. Cover the IRS rules on those. So there'll be a separate one on nonprofits that'll come along here soon. So the theme of this lecture, though, is corporate dissolution, and we're going to introduce you to this topic by focusing on the nature and definition of corporate dissolution and the procedures for voluntary and involuntary dissolution. So your objectives, a little more detailed than what I just blurted out. This is where we're going. So, voluntary dissolution. Corporations, as you know, are given their life by state statute, and they have to be dissolved according to state statute. And most corporations exist perpetually and must be dissolved when there's no further reasoning for their existence. The voluntary dissolutions, they are approved by the directors and shareholders of the corporation. If the voluntary dissolution may be approved by the board of directors if no stock was ever issued. After shares of stock of the corporation have been issued, it must be approved by at least a majority of the corporation's shareholders. It's a little bit confusing of a slide. I had to look at this more than once, but they're just saying prior to commencement of business and issuance, board of directors is all that's required, and after commenced and shares issued, then you need shareholder approval. So, slide number 5. The procedures we follow, they're established by state statutes, and each state will be different. On a general level, voluntary dissolution procedures are typically followed by the dissolving corporation, or what the corporation follows. They obtain approval from the directors and shareholders of the corporation. They file the articles of dissolution, liquidate the assets, pay creditor claims, and distribute the balance of the assets to the shareholders, articles of dissolution, and notice of intent to dissolve. I'm sorry, that should be. They distribute the balance of the corporation's assets to the shareholders, and then finally, articles of dissolution and notice of intent to dissolve are filed. Some states have a requirement that its articles of dissolution or certificate go to the Secretary of State. In some states, a corporation first files a notice or statement of intent prior to dissolving, and sets a date of. And then does the articles of dissolution afterward. So they begin in some states with a notice. After a dissolving corporation has filed either its notice of dissolution, where that's required, or its articles of dissolution, it begins the process of winding up its affairs and liquidating its assets. In Model Business Corporation Act states, Section 1405 lists the several activities: collecting the assets, disposing of the properties that won't be distributed in kind to shareholders, discharge or making the provision for discharge of liabilities for the corporation, and distribution of remaining property among shareholders according to their interests. And lastly, in my lecture notes, I've included every other activity necessary to wind up and liquidate the business and affairs of the corporation. So a notice goes to creditors. All state statutes provide procedures for notifying a corporation's creditors of its dissolution. Corporations that are domiciled in states following the MBCA are given guidelines to follow for notifying creditors of known claims and for notifying the public in the event that there are any unknown claims against the corporation. The notice is sent to the known claimants of the dissolving corporation that need to include, basic information, a description of the information, a mailing address, deadline to send in a claim, a statement that the claim gets barred if it's not received by the deadline. Sounds a lot like probate, doesn't it? All right, under the MBCA, creditors who receive proper notice but don't make a claim, they've waived their claim. It's been barred. They're also barred if they're rejected by the corporation. The claimant doesn't commence a proceeding. So the corporation can reject the claim, and if they do reject the claim, the claimant needs to file a proceeding to enforce the claim within 90 days of being rejected. The statutes of states that follow MCBA also provide procedures for publishing notice. Always best to publish notice on top of the known claims. The unknown claims, this would handle unknown claims against the corporation. I'm sure it's done all the time. Anyway, unknown claims, they could be anywhere. I cannot imagine a lawyer not advising this anyway. So all claims against the corporation get barred if a proceeding to enforce the claim isn't commenced within 5 years after the date of publication. Again, sounding a lot probate. Shareholders may be liable for valid claims made after the dissolution of a corporation, but only to the extent of the distribution they received when the corporation was dissolved. Generally, dissolving a corporation just notify the Internal Revenue Service with a Form 966 and a copy of the resolution and our plan of liquidation. And you not only deal with these activities in the domicile state, but also you need to surrender your certificate of authority in every other state which qualify to do business as a foreign corporation. So the statutes of most states also provide that the dissolution process can be revoked with the approval of the board of directors and shareholders by filing articles of revocation or a similar document with the Secretary of State or the state authority that accepted the articles of dissolution for filing. Involuntary dissolution is also called an administrative dissolution, where the corporation is dissolved by its state of domicile, usually because it didn't pay taxes or file reports. When a corporation has been administratively dissolved and rectifies a situation that causes the dissolution, it's usually reinstated. And there are also just judicial dissolutions. Corporations may be dissolved involuntarily by court action brought by creditors or shareholders. Creditors with a judgment against the corporation that does not have sufficient liquid assets to pay them may bring a judicial action to force the dissolution of the corporation and liquidation of its assets in order to collect on their judgments. Courts may dissolve corporations in proceedings brought by minority shareholders. First, when the directors or majority shareholders are acting in a manner that is threatening irreparable injury to the corporation. B, if the directors have acted illegally, oppressively, or fraudulently. or C, if the corporate assets are being misapplied or wasted. So we're talking about derivative action. Corporate dissolutions are not necessarily due to bankruptcy or failure of the corporation, and corporate bankruptcies do not necessarily mean the dissolution of the corporation. However, the two often go hand in hand, and it's pretty common, it's pretty realistic, I should say, advice to just say, let's just take this corporation through bankruptcy and everything will go away. But the federal bankruptcy courts would have jurisdiction over it. The bankruptcy filing proceeds with a petition for liquidation under Chapter 7 of the Bankruptcy Code, or it could seek a reorganization under Chapter 11. Chapter 11 of the Bankruptcy Code allows companies that are in serious financial trouble to reorganize their businesses without liquidating. Chapter 11 provides a rehabilitative procedure for corporations to retain their assets, restructure their debt, and repay obligations over an extended period of time. And this is what the paralegal might do. And that concludes this almost last, as I pointed out, lecture on business organizations. And like I said, I'm going to do one more that gives some more insight to the public corporations. All right. Thank you. Goodbye. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.